Option to purchase only requires one nickel as consideration. So practically no separate consideration is required. But I'm talking about a lease situation where the tenant is already paying rent. Some court says that the rent that the tenant is paying is sufficient consideration for an option to purchase. So in a lease situation, no extra uh, payment of consideration is required. Just the rent payment is sufficient. It's just an option to purchase is the right to purchase the property for a fixed price sometime in the future. However you determine the fixed price, it is an option to buy a property for a fixed price. Fixed price usually means that you fix the price ahead of time. For example, the tenant has between now and 2 years later to buy the property for $500,000. That is an option to purchase. You cannot have an option to purchase without a purchase price. An option to purchase without a purchase price is an invalid option. Now, what if you have an option to purchase that doesn't have a price, but it has a way to determine the price? That could be a valid option, such as an option to buy the property at the future, at the fair market value at the time the option is exercised, or 95% of the fair market value. Because the fair market value can be determined based on an appraisal. So just because you don't have a purchase price that is fixed ahead of time doesn't really mean you don't have a valid option. A valid option does not require a fixed price, but rather it requires a way to determine or fix the price in the future. Right of first refusal. Right of first refusal is different. All that means is if ever there is an offer made on the property by another buyer, by a buyer, then the offer must be presented to the person who holds the right of first refusal to match that price. For example, if a tenant has a right of first refusal to buy the property during the term of the lease, and any time during the term of the lease, if the landlord receives an offer, the landlord must present that offer to the tenant to match. And usually we specify the amount of time the tenant has to match the offer. It has to be on the same terms and conditions as the presented offer. The tenant has no ability to vary the terms and conditions of the presented offer if the tenant wants to properly exercise the right of first refusal. So what motivates tenants and landlords to have them in leases? From the tenant's perspective, especially when you have like a 20-year or 30-year lease, you want to have the ability to take advantage of the improvement that you've already made. See, tenant, if they make substantial improvement on a long-term lease, they have, other than investment reason to buy this property, they also have other business reasons to stay at the same location. If they buy this property, they own the property, they can stay at this location forever if they want. So certainly, there's a reason for the tenant to want to have the option. Plus, when the tenant gets a new landlord, they have to rebuild relationship. You don't know if they're going to get along with the new landlord. So certainly, if they have the ability to buy it, they want to consider buying it. And the second reason is it is a means for the tenant to afford owning a building in the future. So the tenant is paying rent, such as a residential tenant. Many residential tenants don't have the ability to own a property. And because of that, they want to negotiate with the tenant, an option to purchase the property when they save enough money, save enough. And of course, if you can fix the purchase price ahead of time, it is a way for the tenant to benefit from the increase in equity. All right. Possible higher rent than fair market value to landlord. So that the first three were the tenant's motivation. The next one is really the landlord's motivation to give option to purchase or right of first refusal. Uh, it could be true that the landlord can charge a higher market rent against the tenant if the tenant has the option to purchase or the tenant asks for the right of first refusal, but it's not necessarily so. And the stability of rental income to landlord, because having the right to purchase, the option to purchase or right of first refusal, actually might motivate the tenant to sign longer leases such that the landlord would be able to rely on a stable income, rental income. Option to purchase or lease. Is separate consideration required? In theory, yes, but in practice, no, because it only takes a nickel to have a valid option. How do you determine the terms of an option? Well, I guess it depends on what the parties really want. I mean, do you want an option to purchase or you just want a right of first refusal? Right of first refusal actually means that it actually favors the landlord in the sense that whatever price that you sell it to the tenant, you can actually make it like fair market value. Okay, whereas in the case of an option to purchase, unless the tenant wants to purchase it at fair market value, usually the tenant wants to purchase it at the discount. So the right of first refusal is generally more favorable to the landlord as opposed to the option to purchase. What are the pitfalls and traps for an option to purchase or right of first refusal? Well, actually, from the landlord's perspective, sometimes they might inadvertently agree to receive lesser rent than they otherwise would be entitled to if they're in a normal market where the rent is rising at a significantly higher rate than inflation. So giving the tenant the option sometimes might cause the landlord to have lower rental income than otherwise he's entitled to. And if you have a lower rental income, it gives you lower cap rate, and as a result of which you won't be able to sell it at a higher price. And then as far as trap, the tenant needs to be careful that when they have an option, they need to be aware that these options must be exercised within a certain period of time before the lease expires. During my career, I probably come across at least 10 tenants who missed the deadline and eventually found that they had no place to go. So the tenant must always be aware of the deadline to exercise the option. Next thing we ask, should agents accept a listing on the property burdened with these options? Yeah, if you're the listing agent, you just sign the listing on a property that is tenant occupied. Your risk is that if you receive an offer, and if the tenant has a right of first refusal, will you get paid a commission? Well, if you structure the listing agreement well, you should still be able to get paid your commission, even if the tenant's buying it. So you want to make sure that you communicate with the landlord. You know, if you want to be paid, if a sale is made to the tenant or not. And if a sale is made to the tenant, you get a lower commission. Okay. Whether it's right of first refusal or an option to purchase, it is a risk that you may have, and you need to kind of work around that risk. Right of first refusal, right of first offer, and right of first negotiation. What are the similarities and differences between them? Basically, they are all rights that belong to the tenant. If you have a tenant with right of first refusal, you need to make sure you give him a chance to match the terms and conditions of the presented offer. Right of first offer, it's a little different. Right of first offer doesn't have to involve an existing tenant. It doesn't have to involve an existing offer. You can actually, before listing, have the landlord send a notice to the tenant to ask the tenant wants to be the first person to make an offer on the property. Actually, you might want to actually sign the listing first, and then prepare a notice of the right of first offer. Notice the exercise of first offer to the tenant, and ask the tenant to make an offer. Now, if the tenant makes an offer that the landlord likes, then they can sign a purchase contract. But if the tenant makes an offer that the landlord doesn't like, the landlord can reject the offer. In other words, it is sort of similar to right of first negotiation. Right of first offer can be structured in a way where they can set up some parameters. Right of first offer does not necessarily have to be the same as right of first negotiation, but they could be the same. The one with the least risk, of course, is the right of first negotiation, because that means that the tenant gets to make an offer, and the landlord gets to make a counter offer. They can go back and forth between the two of them, and ultimately, if they negotiated in good faith and the negotiation fails, then the landlord can move on and sell it to someone else. Right of first offer actually could be a little different from right of first negotiation. The right of first offer could mean that if you make an offer and I don't accept, that's no more negotiation. We move on. I guess that might be the difference between right of first offer and right of first negotiation. So actually, the one with the less risk is actually the right of first offer and not the right of first negotiation, because the right of first negotiation actually requires some negotiation in good faith, whereas the right of first offer does not require any negotiation. You make an offer, I reject it, that's it, I move on. Suppose that's a distinction between the right of first offer and right of first negotiation. Should an agent take a listing on a property burden with these terms? Why not? I mean, if you structure your listing agreement well, you may still get paid your commission regardless of who buys the property, whether it is the tenant or a buyer. Okay, that's the end of the slide. If you have, let's say if you have a lease situation, which is a more common situation, I don't have anything here, so I'm just going to fill out some dates. And let's say on April 10, sorry, and we have the name of the option, or let's say Joe Smith is the option. Okay. The option E is Tim Smith. Makes an option on the following terms and conditions, an option to grant the real estate and improvement situated in the city of Los Angeles. So 640 Diamond. Okay. On the terms and conditions specify in the attached. Now we're not dealing with an option to purchase in a real estate purchase agreement, but we're dealing with this situation. Let's say, okay, residential. Okay. And the date is, let's put today's date. Separate consideration for option, as I told you. If you have a lease situation, you really don't need to have a separate one. But if the tenant is willing to pay separate consideration, certainly you can put it in here, $10,000. And it's by any of these methods. See, I told you if you have a lease situation, you don't need to have any consideration. So because it is a lease situation, we can take this out. If it's a lease situation, you can just say, just keep B. Or you can have consideration too. If I'm a tenant, I don't want to pay consideration unless I had no choice. The landlord wants a separate consideration. But usually, you don't need to negotiate a separate consideration. You can actually build the consideration into the rent amount. And here you have a lease, the attached lease agreement data, which is dated, between optionee as tenant and optioner as landlord. If the option is exercised, the lease shall terminate on the earliest of the date scheduled for close of escrow under the purchase agreement or as extended in writing. So it makes sense that if the tenant exercises the option upon close of escrow of the purchase contract, the lease contract is actually terminated. It's the earliest of or the close of escrow of the purchase agreement, mutual cancellation of the purchase agreement. Now, the third one is actually an interesting one. So let's say the tenant exercised the option. And during the escrow, the tenant, for whatever reason, was not able to fulfill the terms of the escrow and have to cancel. And then both parties cancel the escrow. According to paragraph 2B, if the option is exercised, the lease will terminate. Which means that you can get rid of the tenant if you don't like the tenant. But if you like the tenant, you can sign a brand new lease after the mutual cancellation of the purchase agreement. If the option is exercised, or if the option is not exercised, the lease shall remain in full force and effect. So this contemplates that if the lease is exercised, the option is exercised, and the purchase agreement is somehow canceled, then the lease is terminated. So at some point, once the lease is terminated, then the landlord may be able to raise the rent and keep the tenant, or the landlord may decide to get the tenant out. Option period. You should always have an option period. How about we make it, let's say it starts from now. That's the date of signing of the lease agreement. And let's say it expires at 5 p.m. Let's say it's 2 years from now. Which is the same duration as the lease. Now, we didn't even say, is this an option to purchase? It is an option for now, right? So, yeah, it is an option to purchase. So this form is actually meant for option to purchase. It's not an option to renew the lease, which Zipform does not provide for any forms. So for that one, you have to kind of specially draft it in your addendum. Okay, so this is strictly for purchase. No option to renew the lease. Manner of exercise. As with any option, you should always specify the manner of exercise. If the tenant fails to properly exercise, either by missing the deadline or by using the wrong method to exercise, he loses his right to option. So even though a tenant might think that he has option and he's feeling so happy about it, but I've seen so many tenants missing out on the boat, either because they missed the deadline to exercise the option, or they used the wrong method to exercise the option. So if you represent the tenant, it is important you let your client know about these two requirements. Number one, 4, manner of exercise. Optionee may exercise the option only by delivering a written, unconditional notice of exercise signed by optionee to optionor or to whoever that is authorized to receive it. Let's say agent is authorized to receive it. I'm the agent of the landlord. A copy of the unconditional notice of exercise shall be delivered to the brokers identified in this agreement. Number 5, non-exercise. If the option is not exercised in the manner specified within the option period or any written extension thereof, or if it's terminated under any provision of this option, then A, The option and all rights of optionee to purchase the property shall immediately terminate without notice. And B, all option consideration paid, when paid, services rendered to optionor, and improvements made to the property, if any, by optionee, shall be retained by optionor in consideration of the renting of the option. So if it's a commercial lease, tenant has a right to purchase the property, and they make all kinds of substantial improvements to the property. And somewhere along the line, before the current lease expires, and they have an option to purchase the property, and they did not exercise that option, they're going to lose all the improvement to the landlord. C, optionee shall execute, acknowledge, and deliver to optionor. Now, who's the optionee? Optionee is the tenant. Optionor is the landlord. So optionee shall execute, acknowledge, and deliver to optionor within 5 business days of optionor's request a release, quitclaim deed, or any other document reasonably required by optionor or a title insurance company to verify the termination of the option. So I think this is just by agreement to make sure we get the cooperation of the tenant. If they don't cooperate with us to get whatever documentation we need for the title company to reflect that the tenant has failed to properly exercise the option or has failed to exercise the option, then they are in violation of the option agreement. If tenant refuse to cooperate because they missed the boat and somehow did not properly exercise the option, and now they want to hold the property hostage by refusing to sign whatever documents the title insurance company needs. It is a breach of the lease. They could be evicted. So this 5C here actually protects the landlord. Definitely a good provision to have. Here they talk about release. Maybe the title company needs some kind of release from the tenant, or quitclaim deed. Maybe the title company needs a quitclaim deed. Quitclaim deed is as good as a release, just as a release as good as a quitclaim deed, or whatever documentation that is required by the title insurance company. Maybe it's possible that the tenant, maybe it's possible the title insurance company will require something that is easier to obtain than the quitclaim deed or release. So if it's something that's easier to obtain, you want to use that document instead of getting a release or a quitclaim deed of tenant. All right, number 6, effect of default on option. Optionee shall have no right to exercise this option if optionee has not performed any obligation imposed by or is in default of any obligation of this option, any addenda, or any document incorporated by reference. Number 6 is a very important provision. There are many real estate agents who probably did not learn how to properly draft an option. They just neglected to include number 6. And number 6 is such an important provision on an option contract. Now, let's say, for example, you're a real estate agent. You draft a residential lease agreement. It is a 2-year lease with 2 years option, or maybe 2 1-year option. And nothing is specified about the manner of exercise. So uh, let's say the lease agreement has the option period, but doesn't have the manner of exercise, and doesn't say anything about non-exercise, and doesn't say anything about effect of default on option. For an option agreement like this, is it valid or not valid? However, it does state what the future rent is going to be during the option period. Because in order to have a valid option agreement, all the tenant needs is to have an option period and a rent amount for the option period. The tenants are not required to provide the manner of exercise and the effect of default on option. This actually protects the landlord. 4 and 6 are in favor of the landlord. So if you represent the landlord, you want to protect the landlord's interests. You want to provide better service to the landlord. You want to pay attention to number 4 and number 6. The landlord will thank you for that. Just imagine you represent a landlord. You let this one go, number 4 and number 6. Landlord finds out about it. They may not be happy because if the number 4 and number 6 are not in your addendum, and all you got is just a lease with a 2-year lease term and a 1-year option period. I mean, a 1-year with a 1-year option, actually 2 subsequent options periods. What might happen is that the tenant doesn't inform the landlord about exercise of the option, and then goes ahead and pays rent to the landlord the first month after the lease expires. Some cases have said that as soon as the landlord accepts the rent, the option is deemed to be properly exercised. So the landlord might fall into a trap because there was no manner of exercise specified, and there was no effect of default on option. Now, the effect of default on option actually protects the landlord. Now, let's say, for example, during the lease term, somehow for a particular month, tenant was late in making the rent, and because of that, it might deem to be a default of the lease, or the tenant did not obtain renter's insurance, and that's a default on the lease. Anytime you have a material default on the lease, the tenant actually loses the option. So the tenant always have to be very careful. When they have option, they have to watch the lease agreement very closely. For example, the lease agreement might require the tenant to provide insurance, or it may require the tenant to pay for certain things, such as utilities, and tenant is in default. Once there's a default, there is no second chance. They will lose the option. Because if you read 6A, it says, optionee shall have no right to exercise this option if optionee has not performed any obligation imposed by or is in default of any obligation of this option, any agenda, or any document incorporated by reference. If you read 6A, you will realize that there is no second chance. You don't have to give them a prior notice before they will lose their right to the option. Okay, you're a tenant, be careful if you want to keep your option. If you're a landlord, make sure you have number 6 in any option agreement that you give to the tenant, whether it's an option to purchase or a right of first refusal or an option to renew. 6B talks about, in addition, if the lease is incorporated by reference in paragraph 2A, optionee shall have no right to exercise this option if optionor as landlord has given optionee as tenant 2 or more notices to cure. Oh, okay, so 6B actually is quite liberal. 6A applies to a purchase situation, but for such as a developer with a property owner. So 6B actually is more liberal than the one that I've seen. The one that I've seen in the commercial transactions, such as an AIR form, usually we don't have 6B. We don't give second chances. So this one actually gives them 2 chances. So by paragraph 6B, a tenant actually will have 2 chances. So actually, it actually protects the tenant a little bit more. If I were to drop this one for the landlord, I don't give the tenant any chance. If they don't observe the lease agreement, they lose the option. Whereas if you use this one, they actually have 2 chances. So just keep that in mind. Optional disclosure, unless exempt if the property contains 1 to 4 dwelling residential units. Optional shall have 7 days after entering into this option to provide optionee TDS, NHD, notice of private transfer fee and disclosure is required. Now, it's treated like a purchase though. It's once they exercise the option. So unless the optionee has already been provided. So usually no. So usually that's required because it has now become a purchase. And of course, B talks about optionee's right as a buyer for 1 to 4 units, so it's no different. Purchase agreement, it begins on the date the option is purchased. And of course, here you got 6B basically just say whatever that the tenant previously paid to the landlord will be kept by the landlord once the tenant exercises the option. C actually allows the tenant to get a credit. For example, the earlier example that I gave you, the $10,000, that can be applied to what the purchase price according to C. It says here, if option is exercised upon close of escrow of the purchase agreement. Now, this is all negotiable. You can make it all apply to what purchase price or just a smaller amount. Could be like $5,000, in the example I gave you, or it could be nothing because you didn't pay anything. Okay. The rest is just a dispute resolution, damage or destruction. It is now there's a situation where the property is actually damaged before the tenant exercised the option, and in which case the landlord actually has the ability to cancel the option because of destruction. And of course, the optionee will have the inspection right just like a buyer would. Recording, they each have the option to record this memorandum. Usually the landlord does not record it. Usually if anybody is the tenant who might record this. So it's fee broker compensation from optionee. Now this one does talk about broker commission. It says here, if applicable, optionee agrees to pay commission to broker as specified in a separate written agreement. So here you go. This is the one I'm talking about. So when you negotiate your listing agreement, you want to provide for this. Okay. The rest is standard terms and conditions of offer. This is an offer for an option. Nothing really special to talk about. And just like in any other offer, it has a expiration date. An agent that can actually help the buyer or the landlord or the tenant to put together an option agreement with this. This one has all the legal requirements for a valid option. It's a great one to use. However, it's only for purchase. It's not for option to renew. Because it is not an option to renew, for option to renew, if you're drafting a lease agreement for a tenant, such as a residential month-to-month, and you want to provide for option to renew for the tenant, you can actually copy some of this language here and just kind of modify it. You can copy number 4, and you can't really copy number 5 because this is intended as a purchase. But all you need is just number 4. Copy number 4. Okay. And in terms of manner of exercise, you can structure whatever manner you like. It could be by certified mail. Sometimes I see people specify the manner of exercise by certified. Okay. So discuss with your landlord how you want to do this. Number 6, effect of default on an option. You can replicate number 6A. If I represent the landlord, I will not replicate B. I won't give him a second chance. So, depending on who you represent and whose interest you're trying to protect, you draft this thing accordingly. Okay? So that pretty much concludes our training today.